address the board.
As I indicated in the memorandum to all the board members about a week ago, I guess now, bring you up to date on some changes in legislation that was occurring that related to the clubs and organization policy that's been considered before the board. When we first talked about it some time ago, I went over the dictates of the Equal Access Act and indicated to you that for those schools that were subject to the Act, where one club was in that was non-curricular, then all non-curricular clubs were permitted in. But you had the option in those circumstances to create closed forums where only curricular-related clubs were allowed in. That information dealt both with high schools and with middle schools, and the policies were written up that way. As a matter of fact, the policy that was initially approved last week has a particular statement in it regarding secondary schools. Under the Equal Access Act, secondary schools are the schools that are subject to the Act and are defined in the federal law as secondary schools as dictated by the individual states. At the time that we started this discussion of the clubs and organizations policy, there was a statute in Florida which indicated that secondary schools are schools that service children from 6 through 12. That was in, I forget the exact name of the act, I think it was 1003.413, and the law was really dealing with implementation of secondary school education by giving credit for algebra and other high school type classes that were in the middle school when those students matriculated into the high school. Although that particular statute didn't directly deal with the issue of equal access, or for that matter, anything other than the provision of these curriculum services from middle school to high school, it was a definition in Florida law. Since then, I've looked, secondary schools are referenced 65 other times in Florida statutes, and this was the only statute that had a definition attached to it. That law, as of today, effective July 1st, today being the day that the bill was signed by the governor. The governor signed Senate Bill 1076. As a result of that, the statute which previously gave us the definition of secondary schools in Florida has now been repealed, or I should say will be repealed effective July 1st. Where that leaves us is that where before, when we were having the discussions, that middle schools were included in our discussions of the implementation of the Equal Access Act because of that particular definition and statute, that is not now the case. As a matter of fact, in the majority of the cases that I've reviewed in the federal courts around the country that have dealt with application of the Equal Access Act, the majority of those cases, if not all of them that I have reviewed, have all dealt with high school students and not middle school students, and the courts in many of them have discussed the issues of maturity and the students and being able to distinguish between a school-sponsored and a school-permitted activity on campus. As a result, now I should point out this has nothing to do with high schools. The high schools are clearly, under any definition, secondary schools. They have been discussed in the majority, if not all of the federal cases that I've read, so that this is not the discussion about high schools. The discussion is, whereas before it seemed that there was not an issue about middle schools being included in the Equal Access Act, now there is an issue about it. None of the other 60-something places in the statute or 20 to 30 places in the Department of Education regulations where the word secondary school are used gives us a great deal of enlightenment on exactly what that means. They have, in some places, the statutes which, again, are not dealing with the issue before us today of whether the Federal Equal Access Act applies. In some places, the statutes will indicate that there is an elementary school and a secondary school. Some places it talks about elementary schools, middle schools, secondary schools. Some places it talks about elementary schools, middle schools, junior high schools, and secondary schools. So there's no consistency, and these are all statutes that, for different purposes, they're not all education. Some of them are criminal statutes. For example, there's some discussion of what a secondary school is in the criminal law regarding how close felons can be to a school during a school day. In other places, it's educational laws that are dealing with students and as relates to bus travel. One in particular that I cited for you in the memo I wrote was the dual enrollment. Dual enrollment, it references secondary school students throughout the dual enrollment statute. It says secondary school students are the only ones who can dual enroll. Well, in this county, and I believe in every other district around the state for years, that has always been interpreted as being high school students. Middle schools do not dual enroll. So does that give you an indication? Well, it's some indication, but there are other places where it says something differently. Bottom line is, I cannot tell you with certainty, certainly anymore, that the Equal Access Act applies to middle school, and that is an issue now, and will become an issue on July 1st. Up through July 1st, the definition remains for secondary school students at 6th through 12th, but at the end of this school year, that's not going to be the case. So that's what's happened since the last time we met, and I believe I've shared all that information with you, and we're at a point now where the information that we had and how we move forward to high school, there's been no impact at all by this legislation, but there is a change as far as middle school.
And in the process, Mr. Johnson, if we amend the original tentative policy, then we have another 30-day period?
Actually, based upon the way the policy was worded, it would have to be amended because there's specific references to the statute and the definition of secondary school that's in that policy, which I don't believe is applicable. Well, it won't be applicable as of July 1st, and since the primary purpose of this policy in this school year is about over, we're looking at next school year. After July 1st, that won't be the definition anymore. So the most you could do tonight probably would be to make some amendments to the existing policy and then republish it for final approval after an advertising period.
Okay. And that's the process that we have to follow with hearings this evening. Board members, I would like to move ahead with hearing the individuals that are here. I think they've come great distances, unless there's a motion that rises from the spot. Yes, Ms. Franklin.
So, Mr. Johnson, what does that mean for us here tonight? So, do clubs remain in middle schools, or do clubs end at the end of the school year in middle schools? I mean, what does this mean for?
Yes, ma'am. Number one, the equal access. There's nothing stopping you from creating a limited open forum at a middle school, regardless of whether the Equal Access Act applies. The point with the change in the statute is that one time I told you the Equal Access Act does apply to the middle school, so that you were compelled to decide either all clubs in or all clubs out, or create some sort of different limited open forum at it. Now, with the change in the legislation, that's not a mandate for you to do. You're not required to apply the Equal Access Act to middle schools, in my opinion, at the moment. That has not been decided yet. So, what that means from the last time we met is that you still have the ability for a high school under the Equal Access Act to either have all clubs in or all clubs out. All extracurricular clubs in or all extracurricular clubs out. That's still an option under the Equal Access Act. For the middle schools, you're no longer required to do it that way, in my opinion. Assuming that there's going to hopefully be an interpretation at some point here about what a secondary school is in the state of Florida. You have an option to create it however you want to. I will tell you that up till now, what's happening under your policy that exists, if you did nothing tonight, is your principals have been left with the determination of how those forums apply in the individual schools. So that has been left up to them. One of the reasons why we moved forward with this policy in the first place was to try to eliminate the differences from school to school on how that was and have a consistent and certainly following the letter and spirit of the law as to what the policies were supposed to be in the individual school. So if we don't do anything in the future, then what you have left at the moment is an interpretation on a case-by-case basis by the individual school principal.
Madam Chair, I'd like to move that we table the discussion of this policy until we have a full understanding of what the direction should be.
Mr. Matthias has put a motion on the table to table. The motion for tabling calls for a second, but with no discussion. And I want all board members to understand that. It has to be time specific, and you would have to put a date to it. That's my understanding.
Actually, Madam Chairman, for a postponement, we would, the motion for table, it would come up to be removed from the table potentially at the next regular school board meeting.
And that's not my understanding, but you are our attorney.
Well, I'm not an expert in Robert's Rules of Order, no ma'am.
Okay.
Robert's Rule of Tabling gives a specific time period.
Yes, it does. Thank you. Is there a second? Can I ask a question? You can ask a question. There may be no discussion. I understand the table.
So if I come in for the tabling, then I can't bring up my questions that I had done.
That's exactly correct.
Okay.
Is there a second? I hear none. Thank you. We will move on. Yes.
I bring up my questions.
Yes,
As an individual district, since there's so much unknown as to what the new bill does or doesn't do, can we, as the Lake County School District, say our definition of secondary is 9 through 12? Does that put us in a legal battle?
If we assume someone wishes to challenge it, what we call it isn't going to be significant. Well, certainly we can re-emphasize that we are passing whatever policy we're going to pass based upon our understanding of the definition of secondary schools. That doesn't change. If someone was interested in challenges, that doesn't give us a lot of additional assistance.
Well, the one thing that Mr. Matthias did bring up, I mean, I have that same concern. We need to look at the statute and how it actually affects us and how it affects middle and elementary school. Maybe we need to have policies for all of those when we need time to do that in order to move it forward. So,
I'm going to be coming back to you on that question. Dr. Howard?
And this goes along with what Debbie was talking about. I think I'd like to see them split. We were all on the same page as far as part of this policy goes. We need to get some of this policy put in place and then deal with the parts that have become muddy individually so that we can have direct discussion on those.
As your chairman, you're talking workshop, because that's the only way that we can do it. And because of that, I'm going to return to Mr. Matthias, ask him to repeat his motion again, and I'll be passing the gavel to second.
I'd like to move that we table this discussion until such time as we fully understand the ramifications of the statute, and we do not take a vote on it tonight.
Is there a second?
second.
Seconded by Ms. Dozier. All those in favor?
Aye.
Aye. Those opposed? Aye. Okay. It is a 4-1, and is that it's supposed to be a supermajority, I believe that's
Yes, ma'am.
okay. Okay.
Good job, Bill. Good job.
Almost like Bill, you answer the guy and no one else.
And those are yellow, I ask you, please.
Can you move your tripod for me one second?
We're going to
What?
take 5
Your tripod,
minutes.
so I can check this out?